That is after the Supreme Court within the last hour or so denied his request for a delay. Now, barely. The 5-4 decision just came down in the last hour. Chief Justice Roberts and Amy Coney Barrett siding with the 3 liberals on the court, deciding that first, the alleged evidentiary violations at President-elect Trump's state court trial can be addressed in the ordinary course of appeal. That is usually how this works. Second, the burden that sentencing will impose on the president-elect's responsibilities is relatively insubstantial in light of the trial court's stated intent to impose a sentence of unconditional discharge.
Something significant has just happened at the Supreme Court of the United States, and understanding what it means requires careful attention to both what the court did and what it refused to do, because in this case, the refusal carries as much weight as any formal ruling the justices could have issued. The Supreme Court denied Trump's appeal in a single word. No hearing, no oral arguments, no extended deliberation. Just a cold, decisive rejection, 5-4, with 2 of his own appointees voting against him.
Count 31, guilty. Count 32, guilty. Count 33, guilty. Count 34, guilty. That is 34 felony counts here, all guilty verdicts. Savannah and Lester, back to you.
A total victory for the prosecution here. Laura, the jurors obviously bought the prosecution case in full. There was a consideration of whether or not they might split their verdict or compromise in some way. That is not the case. It's a total rejection.
The case at the center of this legal earthquake is the New York hush money prosecution, the one that already resulted in Trump being convicted on 34 felony counts of falsifying business records. That conviction made history before the Supreme Court ever touched it. It was the first time a former American president was branded a convicted felon by a jury of his peers, and the evidence that produced that verdict had been overwhelming. Documents, testimony from witnesses who were present for the events in question, a paper trail that led directly to Trump's inner circle and documented in precise detail the mechanics of what the prosecution alleged had occurred.
Judge Juan Merchan said in a court filing Monday the Supreme Court's ruling giving presidents immunity from prosecution over official acts does not apply to this case. A jury convicted Trump in May on 34 counts of falsifying business records to conceal hush money payments to adult film actress Stormy Daniels in the lead up to the 2016 election. Trump's sentencing had been delayed while the judge considered the impact of the Supreme Court's ruling. CBS News investigative reporter Graham Cates joins us now on the phone. Graham, how does Judge Merchan explain his decision?
But convictions are not the end of the story in America's multi-layered legal system, and Trump's legal team understood that as well as anyone. They immediately went to work filing motions to set aside the verdict, arguing that the trial had been unfair, that the judge was biased, that the charges were politically motivated, that the entire prosecution represented an illegitimate weaponization of the justice system against a political opponent. Those arguments failed before the trial court, so they climbed higher, taking their case to appellate courts and arguing that presidential immunity should retroactively shield Trump from prosecution for actions taken in connection with his time in office.
The Supreme Court has just announced that it is refusing the effort from Donald Trump's team to stay a decision on Trump's sentencing in his hush money criminal case here in New York, scheduled for Friday. Again, the Supreme Court now refusing to stop former President Trump's sentencing. The president-elect was scheduled to be sentenced after being found guilty on 34 felony counts for falsifying business records as it related.
The message embedded in that denial could not have been clearer or more consequential. Presidential immunity does not function as a permanent get-out-of-jail-free card that can be invoked to erase criminal conduct whenever a former president finds prosecution inconvenient. It does not retroactively transform state prosecutions into federal constitutional questions that require Supreme Court intervention to resolve. It does not create a special category of permanent legal protection that sets former presidents apart from every other citizen in the country they once led. By their denial, the justices reaffirmed a principle that should be foundational in any functioning constitutional democracy. The law applies to everyone, including those who once held the highest office in the land.
Now, the judge overseeing Donald Trump's federal election interference proceedings unsealed nearly 1,900 pages of heavily redacted evidence. It's content that special counsel Jack Smith assembled to build his case against the former president. Trump's legal team objected to the release before next month's election, but the judge said withholding this information from the public could itself constitute election interference. Here's Scott MacFarlane.
That is the precedent that will now ripple through every other case on Trump's legal docket, and there are several. The federal election interference prosecution is where Trump faces charges related to his alleged efforts to overturn the 2020 election results, including conspiracy to defraud the United States and obstruction of official proceedings. The classified documents case in Florida involves accusations that Trump willfully retained national defense information after leaving office, obstructed justice, and made false statements to the investigators who sought to recover those materials. The Georgia state prosecution charges Trump under that state's RICO statute with running what prosecutors describe as a criminal enterprise designed to subvert the certified election results in Georgia.
President-elect Donald Trump was sentenced today in New York City, months after a New York jury found him guilty of 34 felony counts of falsifying business documents to cover up an extramarital affair. But Judge Juan Merchan granted the president-elect what's called an unconditional discharge, a sentence that affirms he is a convicted felon but faces no further penalties, fines, or any time in jail.
In the New York case specifically, Judge Juan Merchan, who presided over the trial with a steady hand despite relentless personal attacks from Trump and his allies throughout the proceedings, has indicated he is ready to proceed with sentencing now that the Supreme Court has removed the final procedural obstacle that was keeping that process on hold. Merchan has been patient and methodical and unflappable throughout what has been an extraordinarily pressurized case, but he has also made clear at every stage that he will not tolerate endless delay tactics designed to avoid rather than contest the legal consequences of the conviction. The conviction stands. The sentencing will happen. The question that legal observers are now focused on is what that sentence will actually look like. The general expectation among legal analysts is that Merchan will impose something relatively lenient for this particular case, and the reasons for that expectation are grounded in factors that apply to any criminal sentencing rather than any special treatment of a former president. The charges, while serious as a matter of law, are nonviolent. Trump is a first-time offender on these specific counts, at least in terms of criminal convictions. The logistical complications of incarcerating a former president who carries lifetime Secret Service protection are genuinely significant and present practical challenges that have no clear precedent. These factors together point toward a sentence that might include an unconditional discharge, meaning Trump would not serve jail time and would not pay additional fines beyond what has already been assessed, but the conviction itself would remain permanently on his record. That outcome might seem anticlimactic to those who had hoped to see more immediate and dramatic consequences, but it would be profoundly significant nonetheless. The conviction itself is the lasting and irremovable consequence. 34 felony counts permanently etched into the historical record. The first American president to carry the label of convicted felon, a label that cannot be removed through appeals now that the Supreme Court has declined to intervene, a label that will follow Trump for the rest of his life and shape how history judges him, how voters evaluate him, and how courts in other jurisdictions treat him in future proceedings. Those future proceedings are where the real danger lies for Trump. Because while the New York case may result in a lenient sentence that imposes no additional incarceration, the other cases will not be so forgiving. The federal election interference case is particularly perilous in terms of its potential consequences. Special counsel Jack Smith assembled a substantial body of evidence detailing what prosecutors describe as Trump's systematic efforts to overturn the 2020 election through multiple overlapping schemes. This is not a case about hush money payments or falsified business records, as serious as those matters are in themselves. This is a case about an alleged attack on the fundamental machinery of American democracy from within. The charges include conspiracy to defraud the United States, obstruction of an official proceeding, and related counts that strike at the constitutional order in the most direct way imaginable. If convicted on these charges, Trump faces serious federal prison time measured in years rather than months. The sentencing guidelines for these offenses are deliberately harsh reflecting the severity of crimes that attempt to subvert democratic processes and undermine the peaceful transfer of power that has defined American governance since the founding. A conviction here would mean mandatory incarceration in a federal facility, and the Supreme Court's decision removes Trump's primary defense against that outcome. The classified documents case in Florida carries its own enormous exposure. The evidence in that case has been described as overwhelming by legal observers across the political spectrum. Documents recovered from Mar-a-Lago during a court-authorized search. Testimony from Trump's own staff members about instructions they received to conceal materials from investigators. Audio recordings of Trump himself discussing classified information with individuals who lacked the proper security clearances to hear it. The charges include willful retention of national defense information, which ranks among the most serious offenses in the federal criminal code precisely because of the potential damage that the unauthorized disclosure of such information can cause to national security. Conviction on those counts would expose Trump to decades of potential prison time, and the Supreme Court has now clarified beyond dispute that he cannot claim presidential immunity to escape accountability for that conduct. The Georgia case adds yet another layer of legal jeopardy, and it carries a particular significance that distinguishes it from the federal charges. The Fulton County District Attorney charged Trump under Georgia's RICO statute, the same legal tool historically used to dismantle organized crime syndicates, based on allegations that Trump ran what amounted to a criminal enterprise aimed at overturning Georgia's certified election results. RICO convictions carry mandatory prison time under Georgia law, and unlike federal charges, state convictions cannot be pardoned by a president of the United States. A presidential pardon extends only to federal offenses. Georgia's governor would have to issue a pardon to relieve Trump of a Georgia conviction, and that is a political reality that does not exist in the current landscape. This means the Georgia case represents an independent pathway to prison that Trump cannot escape through the exercise of any federal executive power, regardless of who controls the White House. Each of these cases, standing alone, would represent a serious and genuine threat to Trump's freedom. Together, they form a legal situation that grows more dangerous with each procedural development that forecloses another avenue of escape. The Supreme Court's decision is the key that unlocks all of these prosecutions simultaneously, removing the procedural and constitutional obstacles that Trump had hoped would shield him indefinitely while courts worked through his immunity arguments. The political dimension of this moment is equally significant. Trump is now officially and irrevocably a convicted felon. This is not a characterization created by his political opponents. This is not media commentary or spin. This is a legal fact, established by the verdict of a unanimous jury and affirmed by the decision of the highest court in the nation. The political consequences of that reality are only beginning to unfold in their full scope. Polling conducted throughout the legal process has consistently found that significant portions of Republican voters and even larger portions of independent voters report that they would not support a convicted felon for public office. Those polling numbers will now be tested against actual electoral behavior in ways that will provide the clearest possible evidence of how much the conviction matters to the voters who will ultimately decide future elections. Some Trump supporters will certainly dismiss the conviction as a politically motivated prosecution, as they have throughout the process, echoing his claims of a weaponized justice system and rallying around him with renewed intensity precisely because they feel he is under attack. But elections are decided at the margins, and the margins are where this conviction will do its most significant political work. Suburban voters who have grown exhausted by political chaos, moderate Republicans who value the rule of law as a genuine principle rather than a rhetorical convenience, independent voters who want functional governance from whoever occupies the White House, leaders who respect democratic institutions and expect the same from those seeking their support. For these voters, the convicted felon label is not something that can be easily explained away or forgotten in the heat of a campaign. Campaign advertisements will feature it prominently. Debate moderators will ask about it directly and repeatedly. Political opponents will reference it constantly in the framing they use for every other issue. It will become an inescapable part of the political conversation, shaping perceptions in ways that no amount of rallies or social media posting can fully counter. Beyond the electoral implications, there are practical, political, and legal complications that flow from the conviction in ways that create additional uncertainty and cost. Some states have laws restricting convicted felons from appearing on ballots or holding public office. And legal challenges on those grounds are virtually certain to be filed and litigated in multiple jurisdictions. International leaders who must conduct diplomatic relationships with whoever occupies the White House will view a convicted felon president through a profoundly different lens than any previous American leader has faced. Every meeting, every negotiation, every state visit, every international forum would be conducted in the shadow of that conviction in ways that create diplomatic complications that are difficult to fully anticipate but impossible to entirely avoid. The psychological dimension of this moment should not be underestimated as a factor in what comes next. Trump has spent his entire adult life cultivating a specific and carefully constructed image of invincibility. The brand, the persona, the entire mythology he has built his public identity around rests on the idea that he always wins, that he never faces real consequences, that he is too smart and too determined and too powerful to be brought down by any opponent or any institution. That mythology has now been shattered in the most public and permanent way possible. A jury of ordinary citizens convicted him. The appeals courts rejected his challenges at every level. The Supreme Court, including justices he personally selected and appointed, refused to save him. He is a convicted felon, and that reality cannot be changed by any legal maneuver, any political argument, any amount of public denial. How a person built around the psychology of invincibility processes a loss of this magnitude and this permanence is a genuinely significant question, not as a matter of psychological curiosity, but as a practical consideration for what his legal situation looks like going forward. Trump's behavior in courtrooms has already been erratic at times, producing incidents that have created complications for his legal team and provided material for prosecutors to point to as evidence of the attitude the defendant brings to his legal proceedings. As his legal options narrow and the prospect of actual incarceration grows more concrete and less abstract, the pressure will intensify in ways that are likely to affect his decision-making. Defendants who feel cornered sometimes make choices that damage their own legal position. They lash out at judges in ways that generate contempt findings and unfavorable press. They replace competent lawyers with advisors who tell them what they want to hear rather than what the law actually requires. They make incriminating public statements that prosecutors later use as evidence in the very cases they were trying to defend against. Trump has already displayed many of these tendencies in varying degrees across his multiple legal proceedings. The Supreme Court's ruling may accelerate them as the reality of his situation becomes impossible to avoid. His legal team, already operating under enormous strain across multiple simultaneous high-stakes cases, must now contend with a client who is running out of legitimate options and whose emotional response to that reality is likely to make their already difficult work even harder. More legal team disruptions are not out of the question. More chaos in how the defense is managed is almost certain. The institutional significance of what the Supreme Court has done extends far beyond Trump as an individual defendant or as a political figure, because the principle being reaffirmed has implications for every future president and every future exercise of presidential power. What the court has done is reinforce a foundational principle of American constitutional governance that has been under sustained challenge and erosion for years. No person, regardless of their former office or their political influence or their wealth or their ability to generate popular support, stands above the law. Trump and his allies have repeatedly and consistently argued that prosecuting a former president is somehow inherently illegitimate, that the justice system becomes corrupted when it holds powerful figures accountable for their conduct, that immunity should shield former presidents from consequences in ways that put them in a permanently different legal category from ordinary citizens. The Supreme Court, by rejecting those arguments, has reaffirmed that the United States does not have royalty, that the presidency is a temporary grant of power rather than a permanent shield against accountability, and that when a president leaves office, they return to the same legal status as every other citizen. They can be investigated, they can be charged, they can be convicted, and if the evidence and the law warrant it, they can be sentenced to prison. This precedent will shape American governance for generations in ways that go beyond the immediate consequences for Trump. future presidents will know with certainty that criminal conduct carries genuine legal risk that does not disappear when they leave office. They will know that presidential immunity has real and enforceable limits, that unofficial acts are not protected, that leaving the White House does not erase legal exposure for conduct that occurred while they were in it. This knowledge will change how presidents behave, at least at the margins, because the deterrent effect of genuine legal accountability is one of the foundational mechanisms through which any legal system regulates behavior. That deterrent effect has been weakened by years of argument that presidential immunity effectively places former presidents above ordinary legal accountability. The Supreme Court's decision strengthens it at the highest level of power, and that is exactly how the constitutional system the founders designed is supposed to work. The founders built a government of laws rather than of men precisely because they understood the danger of creating systems where individual power could override legal accountability. They rejected the idea that any official, regardless of their position or their popular support, should be immune from the consequences of their conduct. The Supreme Court's decision honors that vision, and in doing so, it strengthens the democratic institutions and the constitutional principles that Trump's various legal strategies had sought to undermine. Looking ahead, the timeline is now accelerating rather than stretching out indefinitely as Trump's legal strategy had always required. Sentencing in the New York case will proceed, and while the sentence itself may be relatively restrained in its immediate practical consequences, the symbolic weight of that moment will be enormous and historically unprecedented. A former president standing before a judge to receive a criminal sentence. The cameras will capture it. History will record it. Every news outlet in the world will cover it. From there, attention will shift to the federal cases, which have been delayed by the immunity appeals, but will now move forward with renewed momentum. The election interference trial will proceed. The classified documents case will advance.